For the lawyers, which I won't go too much about, the only reason I'm speaking about it is it's important for the donors to be aware. What the lawyer has to be aware of is that you understand all of this. So if you're listening to this podcast, hopefully this will give you a big background of what to expect if you are going through an enduring power of attorney and to understand it. They advise you of everything. They advise you of your rights to suspend, and they need to ensure that there's no undue pressure. Kia ora. First, I'll just introduce myself. No ahi parahau ko te raro me Ngāti Kahunga iwi, ko manako toku kāinga, ko Eden toku ingoa. He roia ho. So I am a lawyer. My name is Eden. I work at Community Law in South Auckland. I've worked there for about 5.5 years now. Love the mahi there. We do a range of everything really. All different types of law. I specialize in criminal, employment, ACC, some family areas, a bit of everything really. Today I will be talking about enduring power of attorney. That may be a concept people are quite familiar with, but I thought it'd just pay to go through the different types of power of attorney that you can have, what they mean, what they're about, how to get one, and just some things to consider when appointing someone as your power of attorney. So firstly, I'll just give a bit of an overview of power of attorney, and then I'll go through some of the documents that I have that explain a bit more in detail and things to just be mindful of. So there are two different types of enduring power of attorney, that is enduring power of attorney for property and then enduring power of attorney for personal care and welfare. One essentially relates to property, financial matters and things, and then one relates to care and welfare, health-related decisions. I would say, in my experience, this is the most straightforward application to do out of anything I've really come across. So I would urge people to take note of this and get an enduring power of attorney done now if you can. We at Community Law are able to assist with this. It can be done literally within 2 hours, if that. And then we send people on their way to get the other things that need to be signed off, and then we finalize it. So in terms of the two areas that you do, generally we always do these for clients side by side because it's just good to have. As a document that you keep for life, or unless you choose to suspend it or terminate it, generally with the people that we get through our doors, they just keep it in place. And it's one thing I would stress that people know is that once someone dies, the enduring power of attorney ends. When they die, obviously the will kicks into place. A lot of people believe that an enduring power of attorney means that it can sort out their affairs after they pass away. It's just important to know that that's not the case. It's only while you're living. And again, it is a document that is great to have, and it's one that you hope you'll never need to use. But again, like the law, there's lots of things like that. And one thing I'll mention is triple PR applications, which kind of go hand in hand with this. But triple PR, which stands for Protection of Personal and Property Rights, that is something that you have to go through if you don't have this document in place. And that is a bit of a long, drawn-out process. It's more onerous and it requires applying to the family court and a lot of the time engaging a lawyer. So yeah, with this, basically, putting it in place, if I was to put it in place for someone, I would be the donor in the situation. And the person that I'd be appointing is going to be called the attorney. And you can obviously have an attorney for welfare and you can have an attorney for property. The reason why it's a document that's done once and just stays in place is because I have the mental capacity to be able to appoint someone. When you lose that mental capacity, you can no longer complete an application or the documents for an enduring power of attorney because you don't have that mental capacity. So I'll run through the steps that might be quite helpful to do in terms of going about getting one. Is firstly, if you want to appoint someone to look after your health matters and your property matters, if you lose mental capacity, because that's one key thing, is that they only kick in once you lose mental capacity. A common situation is and we see it a lot with our koumata and kouia, is dementia. So if someone's, it's a possibility that you get dementia later on in life. One would hope not, but these things can happen. This would kick in once you've lost your mental capacity. But coming back to the beginning, while you do have mental capacity, you have to get a GP or a related health professional to complete a medical certificate for you to say that you have mental capacity. This can be very simple. It can be done on the standard forms you get from the doctor, the same ones that if you would go to the doctor and you needed time off work, same form, just saying that they've, checked you've got mental capacity, and that's all we really need. And obviously we'll assist you ourselves. And I'll come to some stories later about what the mental capacity is actually about, but that's the number one thing that we need. Then you would be deciding who you would want to appoint. And the people you want to appoint for health and property is someone that you trust, so that will promote your best interests. Sometimes it can be someone who can take a bit of a measured approach, especially with health. Typically we're doing it for our family, our parents or our grandparents, and it can be very stressful when someone falls ill. You want someone who can kind of handle the decisions in that time when there is stress at play. So you need to decide who you believe is best to do that. You can have one welfare guardian, one welfare attorney, and you can have two property. You actually can technically have more than two property attorneys, but it gets a bit messy when you have too many people. A lot of checking in and everything. It's a bit easier just to keep with the two, or the one. That's completely fine. And you can have the same person for welfare and property if you wish. You can have, or you can have different people. A typical example is a parent appointing their child. But I would also mention, so you can have one property for welfare, two attorneys for property, but you can have successor attorneys, which are essentially backups. So say welfare, you've got one child that you believe will be the best for the role, and then you've got another child that is available to deal with it if something goes wrong with them, if their appointment's terminated or if they lose mental capacity, and the same for property. You can just note them in these forms, which I'll go through shortly. So the main thing is thinking who you think is best. All we need from you for that is literally their full name, their address, home address, their email address, and their phone number. And obviously knowing that you've checked in with them and that's something they're happy to do. I would say with this, sometimes we do have whānau fighting over who's going to be the power of attorney and things like that. But I should urge to people that it's an onerous task to do. It's not necessarily the funnest thing to do. It doesn't mean you've got control over their assets or their health or be the golden child to make the decisions. It's the fact that you're taking on the responsibility to act in the donor's best interest. And so once you've decided who that's going to be, when you meet with the lawyers, it's fine if you're as the donor is the only person that goes along to the meeting, and then we go through the whole document, which again I'll come to. Then for your attorneys, so we'll do the signature, the lawyer's signature, to make sure we're satisfied the person has got mental capacity, understands what it means to do this application, because you are essentially handing over all your rights to someone when you lose mental capacity, which is obviously, that's a lot of trust you're putting in someone. So we want to make sure everything's fine. And then once those applications are done, then we send you away to get the attorneys, so say in this example, the child, to go and sign the documents in front of a witness. I also should mention one thing that comes up a bit is that doesn't have to be a lawyer, doesn't have to be a JP. It is just someone who has mental capacity, who is over 20 years old and is not a relative. So typically it'd be a neighbor, a friend, a work colleague. They can declare it for you. It's very easy, very straightforward. Which is why I say it's one of the most straightforward things you can do, and it's something that becomes very important later for people. So I urge people to look into this. But yeah, so you go through, decide who you want, and then there's different conditions that can be put into place. So if, for example, you wanted them only dealing with a certain amount of property, just the whānau home, for example, you can stipulate that, unless you want them to have abilities to act on all of your property matters. That's also something that can happen. Typically, it could just be your bank account. Say you're getting a pension or something, then that person can, make sure that's distributed fine. Because these documents, typically, we see it quite a bit, is people wanting to comfort when a grandparent or a parent needs to go into a retirement home, residential properties and things. And a lot of residential properties need a power of attorney in place. And if you don't have it, then you have to go through the family court. Again, more time consuming, more onerous. There's ongoing duties for years, which we will probably talk about in the next session. So that's why it's much better to get these done at the outset. So when you go through these documents, you can have people listed that the attorneys have to consult with. So using this situation, I'll talk about my own situation. I'd say my parents have enduring power of attorneys for each other. They've named each other. I'm one of 5 children. Me and my sister are the property attorneys, and she's also the welfare attorney because she works in the medical space. It just made sense a little bit. But then you can have backups of my other siblings to be the property managers and the welfare attorneys. So that's really important, but because the situation, if you've just got a couple siblings, for example, and the parent wants to make sure that all of the siblings are told about the applications and what's going on and the decisions, you can have a part in there to consult, where you have to consult with the person that they've put in there before any decisions are made. You can have a stipulation in there they have to provide information. Again, that's not necessary. These are both not necessary. They're optional. But it basically means that you have to provide information on any decisions that are made, just so everyone's on the same page. I mean, a lot of whānau will have hui anyways, but you can put it into writing. And then in terms of the welfare, again, that comes in, they both come into play, always come into play when you've lost mental capacity. However, the property can be put in place earlier. Some people use this when they're going overseas, when they want their business to be handled by someone else. You can put that in place, knowing that it will endure after you lose mental capacity, hence the word enduring power of attorney. So those are things to be mindful of, that welfare is to do with the health and things. You can also have in the property side of things celebratory gifts or benefits for other people listed in there. Say you want some grandchildren to have money for tuition or whatever it may be while you're still alive. That's something that you can put in there as well. And so that's kind of the main things about it. I'll go through because there are a certain amount of things that need to be considered, particularly the bounds of what an enduring power of attorney is. We're talking about wills and things like that. But just to go through it more specifically, so I've gone through and pulled out the most important parts that we need to just refresh, is that when you become mentally incapable, the overriding consideration is that for the health decisions and for the use of property, it's in your best interest. The court's always going to look at what's in your best interest. Probably would have heard from previous podcasts and talking about family court, it's always what's in the best interest of the child and things like that. So if, for example, you've got someone acting for your parents, like your sibling, and you don't agree with their decisions, you can apply to the family court to review those decisions and saying that it's not in line with the best interest, and the court can step in and make their assessment whether that is in the best interest or not, because that's a paramount consideration. That's all the court wants to know about, really. An attorney cannot use property for the benefit of themselves. So you can't have any conflicting interests there. That's really important from the outset. And again, if this does arise, then things can be challenged in the family court. We don't want to go there though, so hopefully things can go seamlessly, and that's why it's always good to have this all set up, just so you know who's dealing with what, really. And so I'll just go through the property a bit more specifically about what you can deal with. Again, it's generally most property, if not all property. So you can, if you own something jointly with the person who's the donor, say husband and wife, or de facto partnership or civil union, You can deal with the property jointly because you jointly own it. Say it's a house property. You both, say the wife is the donor and then the husband's the attorney, and the wife loses her mental capacity. The husband is allowed to deal with the property that is he jointly owns with the wife, including obviously her ownership of that, her share. You can reimburse yourself out-of-pocket expenses. So this is when you've had to, use travel costs or legal fees and things like that to make this a power of attorney work. You can receive from your property reasonable professional fees and expenses. As I mentioned, a lawyer or even an accountant who had to do professional work for the attorney's decisions. And you can make loans, advancements, and investments of your property that a trustee could make in relation to a trust property. Again, keeping in mind that the attorney cannot do this for their own interests. They can't go and put the money that the donor provided into their own property. Nothing like that. And so people just need to be mindful of that, because I feel sometimes people understand that they can just have free reign because now they're the attorney, I can do what I want. That is far from the case. So as I mentioned, again, in consulting, you have people noted down if you want. You don't have to. That's completely up to the donor. But it's important, if you have different people acting for welfare and property, then have them talk to each other. They need to be talking to each other. Again, I mentioned the situation, me and my sister, for my parents' backup, and say something happens to both of them, God forbid, then we will step in as the successors, and my sister is for both. So she talks to herself, she's got to she doesn't, in that situation you don't have to because it's the same person. But if you had different siblings or different family members or whoever it may be, then they need to make sure that they're consulting with each other, particularly because a lot of issues overlap, retirement fees, that's health, but then it's also property because it's the financial paying, and as we all know, retirement homes cost a bomb. So that's something to be mindful of. Again, I mentioned before reviewing decisions if you don't agree with them, and you have the automatic right to apply to the court if you are a relative, if you are a medical practitioner, the manager of any hospital, rest home or residential care facility, and a person from a government-funded abuse and neglection prevention service, or a social worker. Typically, this will be family in situations or maybe social workers, but obviously all of the above, but just commonly speaking, it would be family not feeling that the decisions of other family members are in the best interest of that parent or whoever else, it may be grandparent, typically. And so the court can step in if they've got concerns raised to them. Again, only if someone applies to the court about that. They can modify the scope if need be, which I'll actually just mention something else about that, is that the court will come to a triple PR, but the court will always want the person to be involved as much as possible. It's kind of commonplace here as well. If the person doesn't have the mental capacity, but they kind of can understand a little bit in things, they'll try to be involved in that process. I should just maybe touch on that briefly when it comes to triple PR without confusing things as much, is because, which we'll come to next time, is that when an enduring power of attorney is made, the person who gives up their powers chooses. That's why it's a one and done application, stays in place for life. When the person has lost mental capacity and they need a power of attorney in place, for example, going to a rest home, because as I mentioned, a lot of rest homes require this. The person's already lost mental capacity. They cannot fill an EPOA and they're legally stopped from doing so, essentially. However, the other family members that want to act for them have to apply to the family court so they can make decisions on their behalf. But because that person's not deciding for themselves, their family is saying, I'm the best person to operate in their best interest, the family court has to be satisfied of that. And the family court will oversee that ongoing. It requires 3 yearly reviews. It requires, if they make over 40,000, which is quite a lot, is a low amount unless it's just on the pension or something with no other income, then they have to file annual returns of what they spent their money on, things like that. It's quite burdensome. So always important to get this in place first. Again, if you put one in place and then you decide 10 years down the track while you've still got mental capacity, actually, I don't want that person anymore, or say you had a partner, the relationship broke down, and they were previous to your attorney, then you can redo it. Simple as that. Again, easy process. You tick a box, I revoke all previous enduring power of attorneys, and then just do the new one. A couple other things is if you have for property, as I mentioned, you can have two. You can note whether they act jointly or severally. So person A, can they make decisions on their own, or do they always have to consult with person B? It's a box tick in the application. A lot of people want them to make decisions together, but say one's overseas, then yeah. And on that as well, it's easier if you're trying to decide what child should I have. Easier someone that lives close, that can manage your welfare. We have a lot of the time people coming in and wanting to make an attorney that's over in Aussie. Fine, like for a successor, but what happens if it's a health and it's an urgent and then they're a flight away? Again, we've got FaceTime, we've got setups to talk to hospitals and things, but it is a lot easier if you've got the person who's kind of there. If you've got a child who comes along to appointments with you all the time, perhaps that may be the best person. So one of the other things I will come to is, when you're mentally capable, I should touch on that, mentally capable. This is an interesting term. Essentially, really means testamentary capacity, which essentially means that someone understands the effects of enduring power of attorney. Maybe bring me to the story that kind of shed some light on when you can get an enduring power of attorney. Again, doctor's note, if you got that, that's the gold standard. Because we're not doctors, we can't assess in the same way that they are. We can, sit across from the table from someone and clearly see that they've got their mental capacity. But why it's also important to have a medical certificate is because if someone was to challenge it later, they didn't actually have mental incapacity at the time, but we've got a doctor's note that says they do. So it's a safeguard on all aspects, really. But it was a situation a few years ago. One of my colleagues, he had a client who was doing an enduring power of attorney for, and they had a doctor's certificate from one doctor on X date saying that they had mental capacity, and then another doctor 2 weeks later saying they didn't, or perhaps it was the other way around. But there was two conflicting doctor's notes in a very short span of time. And so because you're on the cusp of it, the lady had dementia, what should we do as lawyers to safeguard ourselves, because we've got this information? So he asked me, being independent from the situation, to go and meet with the lady and her daughter who she wanted to appoint and check if I believe that she had testamentary capacity. Because some people have cognitive issues, some people have dementia. Obviously, there's a whole scale of dementia. I'm just using that because it's the most common scenario that we see. There's a whole scale of seriousness of it. And so she, could do her daily things and that, but her daughter helped her out a lot. Talking to her, I could clearly tell that her daughter was acting in her best interest. I could clearly tell that she understood. So I was like, what does it mean to you for an enduring power of attorney? It just means my daughter can look after me and make the decisions. She already goes and gets the shopping for me, and she already takes me to all my appointments. It was, she keeps me righteous, I remember her saying to me. And so all of these things, I could tell that there wasn't any undue influence going on. This daughter was completely acting in her best interest, and the mother, the grandmother who had the dementia, she clearly knew what she was doing. Even though she had cognitive issues, she knew what she was doing. So I was satisfied that she had testamentary capacity or mental capacity for the purposes of this, even though obviously she had capacity issues because she had the dementia, which affected other parts of her life. So it's not a foregone conclusion if someone has dementia or Alzheimer's or cognitive issues that they can't get this. Again, much easier to get it, so if you can, try. Yeah, it's also just important to keep records of things just in case things do come up later. If there is, transactions and stuff, big transactions, if there's anything like that, the day-to-day little things, I went and bought them food, their lunch, because they needed shopping or whatever it may be. That's not necessary. But it's really good to have records of any big things in case it needs to come up later, just to ensure that you're keeping everything, in order. There are a few terms that I'll just go through quickly before I move on to just some of the things that are specific for welfare and property. And as by this point, you'll probably see that there is quite a lot of similarities with both. There's just a couple of different considerations, but they are one of the same same. They look the same, these documents. They operate very, very similarly, and they're just always good to get done at the same time. So with the will, because this is a question we get asked as well, because there is obviously an overlap in terms of, around perhaps maybe later on in life of what goes on with property and things. As I mentioned before, a lot of people are on the misunderstanding that an EPOA means that they can deal with property after they pass away. That's not the case. You do need a will if you want to ensure that your property is going where you wish it to be. Otherwise, it will get distributed as per the courts and the legislation that is in place for that. But the law is that you can't make a will for someone if you're their property attorney. It's only in the most extremely limited situations that you can kind of adapt a will and things, because the law is important that anyone making a will must have testamentary capacity. They must understand the nature and effect of what they're doing, who might have a claim to their estate, what they are disposing of, and how they are disposing of it. So yeah, it's very, very limited situations that a will can ever be dealt with the assistance, obviously, of the family court. It's not something that you can just go, I'm a property manager, I'm going to go make a will for this person. There's not that ability. Again, we can't talk about medical certificates and having a relevant practitioner to do that medical certificate. If you're seeing someone, if you've got different issues going on, say it's a neurologist or something like that, then they can write that letter for you. Say if you're going to 2 doctors. Out-of-pocket expenses, again, I mentioned that if there's certain fees that need to be put in place that are for the purposes of this EPOA and actioning that. And that's the main ones for this. So again, for those watching on video, there's just documents that look like this really. It's very straightforward. What we fill in, a lot of it is repetitive. If you've got previous enduring power of attorneys, we put your attorney details, things like that when it becomes in effect if you're dealing with a property. And so yeah, it's very straightforward on that one. I'll just go through the welfare because there was a couple of things that were a little bit different for the welfare. But so that's the property information. Again, to summarize, it's property matters, finances, businesses if you have them. Again, you can stipulate what's included. If you just want someone in place to deal with one certain thing, you can put that in place. You're the donor, you decide what happens after you lose mental capacity, if you lose mental capacity. As I mentioned, it's a good to have and hope you don't need, because we hope that we all will keep our mental capacity as long as we possibly can. So with the personal care and welfare one, this is when your attorney can make decisions on a significant matter relating to your personal welfare. It's when your attorney can make decisions about any matter relating to your personal welfare that is not a significant matter. If you were to decide on a significant matter, then you'll need the relevant medical practitioner to provide that in a letter or a medical certificate. Or again, obviously, if the court has stepped in and said that's okay. It's just really important to know that you will work in. You won't be the one making all the decisions. You're working with the doctors and things. You're not expected to have their medical knowledge. It's just like any old doctor hospital situation. You're going to be getting the advice from the doctor and then making decisions, helping make decisions accordingly. And again, when it comes to welfare, it's always good to tell your family, say you're appointing your children, again, commonplace, that's why I use that example. Really important for them to know what you want, what your wishes are, the non-resuscitation and things like that. If there's, which again, this is a significant matter, so you also need the approval of a doctor, but good for them to know what you want, really, in terms of any health decisions. So yes, when it comes to, just to summarize that, when it comes to significant matters, you need the approval of a doctor through a medical certificate. When it's just normal matters, then you can have, not significant matters. You can make decisions as long as you believe that they're reasonable and that they're reasonable in the best interest and that there's mental incapacity that is at play. This is important with the welfare. It's how it differs to the property is what can your attorney not do? And there obviously are some things which include, obviously these are if you haven't put their stipulations in or restrictions already, these are just the standard ones your attorney cannot do, which maybe will be obvious, but it's good to go through them, is make a decision entering you into a marriage or a civil union, or dissolving your marriage or civil union. You cannot make a decision about the adoption of any of your children. They cannot refuse to consent to you having medical treatment that might save your life or prevent serious damage to your health. You cannot consent to you having electroconvulsive treatment or any surgery or treatment on your brain that's meant to change your behavior. And they cannot consent to you being part of a medical experiment unless it is to save your life or prevent serious damage to your health. Again, those are quite obvious ones, but just good to put them out there. And the overriding theme is that your attorney cannot act for their own benefit or for the benefit of anyone else other than you. It is all about your best interest, which is why I urge you to get someone that you trust and that you know that will work in your best interest for you. I've gone over the fact that the welfare needs to consult with the property manager, property attorney as well. And that speaking about the court, which is one of the last things I'll go through, is that the court, as I said, can step in if there's an issue with the decisions made by the attorneys, and that is something that they will only know about if you apply, which is, unfortunately, you have to go to court for that. But if you become mentally incapable, the court can also, one, decide the meaning or effect of your enduring power of attorney if it's unclear. This could be if you've restricted something and it's a bit on the fence in the grey area whether you're allowed to do X, Y, Z or not. They can make a direction on what you're allowed to do. They can decide if your EPOA has ceased to have effect. They can give directions on any matter relating to your personal care or welfare. And they can alter the scope of the personal care and welfare, or they can order your attorney to provide any information that they hold. And they can decide if the enduring power of attorney was obtained by fraud or undue influence. That is an important thing. Sometimes we do see when people come through, if there's a vulnerable adult and someone has an ulterior motive, we hope that doesn't happen often, but unfortunately the reality is that it does. And it's important to know in those situations, obviously the lawyer should be all over that in the first instance, but in the off chance that it does go through the courts, it's ensuring that this person hasn't been kind of pushed into signing their rights over to someone else. And if there are serious issues, they can revoke that appointment too. It's a very controlled process. Even though, as I said, it's a very simple application to do, there are legal ramifications if you don't act in the best interest of the attorney and you do things for your own benefit, or if you breach your duties in any other way. And again, this comes in play when you've got the mental incapacity, and it'll continue until the EPOA is terminated, the appointment is ended, and typically it's when the person passes away, because at the point of death, this ends, which is why I talked about the wills before. And so for the lawyers, which I won't go too much about, the only reason I'm speaking about it is it's important for the donors to be aware. What the lawyer has to be aware of is that you understand all of this. So if you're listening to this podcast, hopefully this will give you a big background of what to expect if you are going through an enduring power of attorney and to understand it. They advise you of everything. They advise you of your rights to suspend, and they need to ensure that there's no undue pressure. We always meet the donor, and if the attorney is there as well, we'd always meet them separately. Wouldn't have the attorney in the room the whole time, just to make sure this is what the person wants. And again, one thing is just if you are going through these and there's language barriers and things, always good to have someone who's independent who can translate too. So with the mentally incapable, again, this is, as I said, I spoke with that story before about the grandmother and the daughter, that she was someone who on the fence, does she have mental incapacity or not? But we had to go through certain things to make sure that she did. And in that case, I was satisfied. We got the doctor's certificate, but in that case, satisfied that she could make a decision, understand the nature of the decisions, or see the likely result of decisions or any failure of the decisions, and communicate those decisions as well. Because obviously some people, if they're nonverbal, if through whatever injury or disease that they may have, that can be difficult to do. So yeah, their relatives, are just briefly touching on a couple of these points to be aware of. When I said anyone's got the automatic right, any relative, it's talking about parents or grandparents, child or grandchild, brother or sister. This is half siblings included, aunt or uncle, niece or nephew. Those are the ones that you can't have the cousin sort of situation applying to challenge things. And those are the main things really that you need to go through. I'll just have a look if there's anything else in it, but I feel that I have covered it all. Yeah, that's pretty much the enduring power of attorney. So to finish off, it's basically the checkboxes that you've got mental capacity. Again, if you are going to a lawyer, get a doctor's certificate first, because I'll just send you away to go get one afterwards before they do anything. So you can do that. We do them at community law. That's completely fine if you want to come in, if you meet our criteria, which is an income and geographical criteria to do so. Very straightforward. We'll get all the details, we do the lawyer certificate, and then we'll send you on the way to go and get the attorneys to sign. And I would mention it has to be the originals. So, for example, we did one recently and the successor attorney lived in Australia. You can't just scan it, send an email and get it back. You had to post it. You have to make sure it's the original with the writing on it, the clear signature. Send it over there, send it back in the originals, and you hold on to those. So again, you can go to any lawyer. The firms will keep a hold of the originals. They'll provide you with a copy. And if anything ever happens, you obviously tell your family what firm or what barrister, solicitor did your enduring power of attorney, and they just go back to them if you ever lose your mental capacity. With us, if you were eligible for our services and wanted to come to get your enduring power of attorney through us, because we're not set up like a normal firm, we always give the originals back to the clients and they need to keep them and do not lose them. Because if you lose them, fortunately, you then have to go through the family court to do the triple PR applications. And just to wrap up, just to keep in mind why I stress to get these done now if you don't have one in place, is that once it's the point of losing mental capacity, whether you go for an enduring power of attorney, which is super straightforward, or you go through a triple PR application through the family court and have ongoing duties for years, it all comes down to whether you've got mental capacity or not. And unfortunately, people leave it too late, and sometimes they just don't come until there's an actual problem, which I mean a lot of us do, so completely understandable. But if you can get onto it quickly and sort it out, that's much easier. You can have a look at these documents on Ministry of Justice website as well, or even contact us and we can send through the forms about the standard effects and implications. If you are going on the Ministry of Justice site just to have a check it out, you will just type in MOJ, find a form, go onto the website, write EPA in the find a form part, and it'll come up. And it's down the bottom, I believe, and just saying these are the standard EPA forms for property and for personal care and welfare. Again, if you wanted to be super onto it, you can start filling it in yourself and then come to us, check it out, and we can make sure that it's all fine and dandy. And this is also one thing I'd mention, I've seen it a few times, is when parents have children that are disabled or haven't had mental capacity since birth for whatever reason, whatever disease or anything, or conditions, they do run into some issues when the child turns 18 because they no longer have the ability to, as the parent, to manage their affairs. So sometimes we have seen that, especially if the child wants to apply for a benefit, then the parent actually needs this to be done in some cases. And if you ever need to action it, if you're ever the attorney who needs to action it, you just take the documents, you show the bank, the rest home, whoever it may be, what it is, and that will be your proof that you've got one in place. So yeah, personal care and welfare and property, 2 pathways, really simple to do. Stress you to get onto it so you don't have problems later. Thank you.